In this documentary, I will discuss the history of food safety, where it began, where we are now, and the legal rules that guide them. In ancient Egypt, often only the priests would prepare the food for the pharaohs. Egyptians believed that cleanliness would help in the preservation of disease. Oftentimes, to store their food, they would put their food in clay jars and store them below ground, where it was often cooler in such an arid and dry climate. Inking was another method that they would use. They would dig a hole in the ground and line it with wood and leaves, and then they would place the food in the holes for storage. In ancient Italy, especially Roman society, they would use mass storage of chilled rooms for a lot of their different kinds of foods. Also, they depended on food that could be easily dried and saved in jars for later service. A lot of their foods depended heavily on legumes like garbanzo beans, millet, and barley. They were also well to use with wine and olive oil. Ancient Chinese developed many different techniques that we use today for a lot of our different foods, such as fermentation, drying, and salting their food to preserve it. We also use curing, pickling, burial, and sugaring for preservatives still to this day. Most dietary laws are based on perceived cleanliness of certain food items. In Islam, dietary laws are based off of the Quran, that is halal. Dietary restrictions are no consumption of blood of any animal, no pork or any animal found dead, only eating animals that have been killed in a certain way of releasing the blood as quickly as possible. No eating food that has been offered or sacrificed to idols, and absolutely no alcoholic beverages. For Buddhists, their number one rule is to do no harm. Most common is a lacto-vegetarianism diet. Under Jewish kosher rules, guide for practicing Jews are that food must be kosher from harvest, slaughter, preparation, packaging, and within food combinations. Pork and shellfish are not allowed in the kosher diet. For the Catholic religion, there is normally no meat allowed on Fridays during Lent. They are to fast on Ash Wednesdays and Good Friday. Usually during the year, practicing Catholics only eat fish on Fridays, and they do not eat until after Mass on Sundays. It is interesting to note that fish or any non-mammal meat is considered okay on Fridays. That means reptiles, beavers, fish, and pretty much anything that lives in the water majority of the time. During the 19th, 20th, and 21st century in America, we had many changing food codes. In 1848, we had the Drug Importation Act, first laws to actually regulate food and drug. 1890, President Harrison put first into law about inspecting the quality of meat for export. 1902, the Poison Squad, group led by Dr. Wiley, was to test the effects of chemical preservations in food. In 1906, the Pure Food and Drug Act. The FDA established from this act, inspired by Upton Sinclair's The Jungle, which revealed the horrors of the meatpacking industry. In 1906, the Meat Inspection Act. 1926, USD Poultry Inspection. 1938, Federal Food, Drug, and Cosmetic Act. 1957, Poultry Products Inspection Act. 1966, Fair Packaging and Labeling Act. 1970, Egg Products Inspection Act. 2001, Food Safety Modernization Act. This started the requirement of using HACCP, which is the hazard analysis critical control points. And in 2020, it was the blueprint for a new era of smarter food safety, listing the 4 core elements: tech-enabled, smarter tools, food safety culture, and new business models, and retail authorization. Negligence in foodborne illness claims. Negligence defined by Everhart, Sarah, and Alexion, Ashley. A negligence claim can be made if the defendants in the lawsuit were negligent in their handling of contaminated food which led to their sickness. Negligence can be established if the manufacturer or distributor failed to exercise reasonable care in producing the product. The box had a E. coli outbreak in Washington state. 73 locations were linked to the E. coli outbreak. 700 people in 4 states were sickened. 171 were hospitalized and 4 had died. This happened because employees at the Jack in the Box decided that their burgers were too tough if they were cooked to the proper temperature to prevent E. coli. This resulted in over 161 million in both court and lost sales for Jack in the Box. Another example is from Chipotle Mexican Grill between the times of 2015 and 2018. They had several different outbreaks. 2015, E. coli in Seattle, Washington. 2015, Salmonella in Minnesota. 2015, norovirus in Sin Valley, California. 2015, E. coli in Washington and Oregon. 2015, norovirus in Boston, Massachusetts. 2017, Sterling, Virginia. 2018, food poisoning in Powell, Ohio. Chipotle was made to pay $25 million in to resolve the criminal charges held against them for the foodborne illnesses outbreaks that they had between those years. More than 1,100 people were sickened from these outbreaks. In December 2015, a norovirus incident at Chipotle restaurants in Boston sickened 141 people. This virus was because the manager was sick, and instead of going home, he was told that he had to continue working while he was still vomiting. Strict products liability and foodborne illness claims. Strict product liability defined by Everhart, Sarah, Alexon, and Ashley. Legal doctrine under which a party whose business is selling or distributing products and who sells or distributes defective product is liable without proof or fault for harm to an injured person caused by the effect. An example of a strict products liability case is the case against Wanabana applesauce pouches. In 2023, a Florida couple's children developed lead poisoning after they consumed several contaminated pouches from the company. In the past couple years, they've had 93 confirmed lead poisoning illnesses due to these cinnamon apple pouches. What's going on is the cinnamon has been altered through a lead chromate, which is a toxic chromium that gives spices a brighter color and appear. This litigation has been going on since 2023 and is still ongoing. Breach of warranty in foodborne illness claims. Breach of warranty, defined by Everhart, Sarah, and Alexon, Ashley. Liability is established if evidence shows 1. Product was not reasonably fit for the ordinary purpose for which it was sold, and 2. Such a defect caused injury to the ultimate consumer. A case example of breach of warranty in foodborne illness claim is Thacker versus Kroger and Company. In June 29th of 2002, the USDA notified ConAgra that its beef contained E. coli that was produced on May 31st. Conagra immediately sent out a recall for all their ground beef chubs. Kroger did not produce or take any of those beef chubs from them. On July 19th, Conagra expanded its recall to include all beef chubs and trim from April 12th through June 29th. Kroger did have these. They then produced a press release requesting Missouri consumers to return them, and notices in all of their stores. Early in July, Christy Thacker purchased the ground beef, and her family ate it in the first couple weeks of August. One of their children got sick with E. coli. However, the Thacker's beef was never tested to confirm the presence of E. coli. Thus, the burden of proof is on the plaintiff. The courts ruled in favor of Conagra and Kroger since the ground beef that was consumed was not tested. In conclusion, The Jungle by Upton Sinclair in 1906. He meant this novel to stir up change for the workers' rights. But instead, society was more concerned about how the meat was processed. Through litigation, how are we keeping food safe through the new food safety laws? The different cases being heard of foodborne illness, negligence, strict product liability, and breach of implied warranty we can use to continue to create a safe space at our dinner tables.